Hello friends, welcome to our channel Khatri Steno. Subscribe our channel for more dictations on daily basis. Get ready for the dictation. We have heard Miss Bhatti Learned ASG appearing on behalf of the applicant Director General within bracket prisons New Delhi. The present application has been preferred by the Director General within bracket prisons New Delhi seeking appropriate directions for surrender of prisons oblique inmates who had been released on emergency parole or interim bail pursuant to the recommendation of the high powered committee in compliance with the orders dated 23/3/2020, 7/5/2021 and 16/7/2021 passed by this court in Shiomoto writ petition number 1 oblique 2020 as the COVID 19 situation has now normalized. It is not in dispute and cannot be disputed that all those under trial prisoners oblique convicts were released on interim bail oblique emergency parole, taking into consideration the overcrowding in the prisons and to prevent the spread of COVID 19 virus among prisoners in overcrowded prisons. All those under trial prisoners oblique convicts therefore were not released on merits but were released on the aforesaid ground alone. At this stage, it is required to be noted that so far as some other states are concerned, all those prisoners oblique inmates who were released on interim bail oblique emergency parole pursuant to the recommendation of the high powered committee constituted in compliance with the orders passed by this court passed in Shiomoto writ petition number 1 oblique 2020 have been recalled. In view of the above, we allow the present application with an observation and direction that all these oblique those under trials oblique convicts who have been released on emergency parole oblique interim bail pursuant to the recommendation of the high powered committee in compliance of the orders dated 23/3/2020, 7/5/2021 and 16/7/2021 passed by this court in Motto writ petition number 1 oblique 2020 have to surrender before the concerned prison authorities within 15 days. The present order be intimated to the concerned accused oblique inmates by the concerned jail authorities that they have now to surrender within the period of 15 days. However, it is observed that thereafter, after the concerned prisoners oblique inmates surrender before the concerned prison authorities, it will be open for the concerned under trials to pray for bail before the competent court and their applications be considered in accordance with law and on its own merits. Similarly, after the surrender by the concerned convicts who are released on emergency parole, it will be open for them, if so advised, to pray for suspension of sentence before the concerned court in their appeals which might have been pending, which also may be considered in accordance with law and oblique or merits. The extent or degree of leniency to be shown by a court. The courts view applications relating to lawyers' lapses more leniently than applications relating to litigants' lapses. The classic example is the difference in approach of courts to applications for condonation of delay in filing an appeal and applications for condonation of delay in refiling the appeal after rectification of defects. Above are the principles which should control the exercise of judicial discretion vested in the court under these provisions. The statutory provisions mandate the applications for condonation of delay and applications belatedly filed beyond the prescribed period of limitation for bringing the legal representatives on record should be rejected unless sufficient cause is shown for condonation of delay.